SJC-10993, Commonwealth versus Scott Foxworth.
Good morning, Your Honors.
Hang on.
Second, Mr. Seeger, just restrain your enthusiasm for one moment. Okay, now you may proceed.
May it please the Court, my name is Ken Seeger, representing the defendant, Scott Foxworth. Your Honors, the first issue that I would like to discuss this morning concerns the issue of the jailhouse informant. And as the Court is aware, the jailhouse informant was a very important witness for the Commonwealth. His testimony contained a confession by Scott Foxworth. The defendant filed a motion to suppress that statement, alleging that the statement violated the Sixth Amendment rights to counsel. And as the Court is aware, the law is that the Commonwealth may not introduce statements if they were deliberately elicited by the Commonwealth without counsel being present. And that rule applies to informants if they are agents of the Commonwealth. In this instance, the defendant is suggesting that Mr. Hickey was in fact a government agent, had become a government agent.
When?
I'm sorry, Your Honor?
When do you say he became a government agent?
I was just about to go through the timeline. He wrote a letter in November of 2006, and obviously he was not an agent at that time, and that's when he first provided information containing a confession of the defendant.
The letter to his grandmother?
He wrote it to his, sent it to his grandmother, and he asked his grandmother to then send it to the detective. The letter made its way to the detective. They brought Mr. Hickey into the Suffolk DA's office and had a discussion with him.
Is that in March of 2007?
That was in March of 2007, and I would suggest that it's during that meeting or after that meeting that an agency relationship arose. And this is despite the fact.
On that point, and I did not read the transcript of, I haven't read any of the transcripts, but not of the hearing on this motion. When it was a state police officer, correct? State police detective?
That is correct.
When he said, I will pass the information on to the prosecution, that was simply that I will pass what you have just told me on. He didn't say, I will make your, or you say that's implicit in it?
It's implicit. Well, he did say, I will pass your cooperation on to the district attorney's
I
office.
will pass your cooperation on, or I will pass this information that you have just volunteered to me on?
I believe it's one and the same. I mean, not just cooperation. I will pass this information on to the district attorney's office. I think that's pretty clear what he said. He also asked Mr. Hickey what he wanted, and Mr. Hickey said very clearly that he wanted a break on his Suffolk County case, which was an armed bank robbery case. So it's very clear at this point, I would suggest. And Detective Donahue did say, we are not promising you anything. No promises, no
I'm not an
inducements,
agent
no
of
rewards.
anybody.
We're not doing anything for you, but what do you want out of this? And Mr. Hickey told him. The recognition of cooperation has been sufficient, I believe in Commonwealth versus Murphy, to create an agency relationship. Now, both parties, and this is implicit, of course, and I think that the court needs to read between the lines and recognize that there really is an implicit agency relationship here. It's an agency relationship, implicit or otherwise, because
Stop for 1 minute, though.
Sorry.
With respect to, I don't know what the testimony was about what Mr. Hickey told the state police detective in March, but you would agree that whatever that was isn't tainted by anything, correct?
Well, I would agree with that, and certainly nothing prior to that, the letter would not be tainted by it. And that's important, but it's important to see that an agency relationship is arising at that meeting. And really what's happening here, despite the words, you're not our agents, you're not to do anything for us. We're not promising you anything. It's implicit, because both parties know exactly what they need to do. I
Well,
mean,
if-
there's
if-
no,
If you're right, I mean, this is almost a textbook case of the state police officer saying just what the law says you're supposed to say.
Right.
If you're correct, essentially every jailhouse, every person who says, I have information I want to give you and I want to be rewarded for it, becomes an agent upon communicating that to law enforcement.
well, and this is the problem. I mean, the Commonwealth, and this is what's discussed, I believe, in Commonwealth versus Murphy, should not be permitted to really, in effect, is what's happening here, circumvent this rule that statements cannot be introduced if they were deliberately elicited, should not be permitted to circumvent that and to dilute the protections of the Sixth Amendment merely by saying, you're not our agent. There are cases out there, for example, I believe Commonwealth versus Rancor, where there was some vague relationship. You help us out with something, we'll help you out. But that's not what's happening here. This is very specific. Each side, each party to this, the informant and the detective, they know exactly what they want. This is specific. This is nothing vague, like maybe we'll help you out someday with something. Each party knows exactly what it needs to do. And despite the fact that Detective Donahue says, you're not to ask any questions, you're not really our agent. I mean, really, Your Honor, isn't this a circumstance where it's nod, nod, nudge, nudge, wink, wink, we both know what's going on here. You're going to help us get this confession, and we're going to help you with your case that's coming up. And also, I should point out that just to further show that there was a relationship here, there was a motion to revise and revoke that was filed very late, 6 months after the 60-day rule in Barnstable County. Mr. Hickey's sentence in Barnstable was reduced.
Is there any indication that that was because of this cooperation? I thought that the Commonwealth says none whatsoever.
None whatsoever.
Or the Barnstable one? Maybe I'm wrong.
And so there's a sentence in Barnstable, which is 2.5 years receiving stolen property. He's taken to Barnstable. It's way over 60 days. And I believe there's something in the record on the revise and revoke that he's being taken there to reduce his sentence, to get him to Maine, to protect him from any possible harm that may result from being an informant. So his sentence is reduced, and his bail on the Suffolk armed robbery is reduced to
But he's going right
personal
into,
recognizance.
but only so he can get to, it's not like he's going to be floating on the street.
Right, well, exactly. I mean, the point is, not an agency, they're getting him out of Massachusetts. They need to protect him so that he can testify. And look what happens right after this Foxworth trial.
Yeah.
This trial is in, I believe it's June of 2009. There's a guilty verdict. 1 week later, he's in federal court being sentenced. And we know what he wants, and we know what the minimum is. He's given way below the minimum because the federal prosecutors have agreed, pursuant to his cooperation, to file a motion for a downward departure.
I understand all that, but the two of them parted ways in January of 2008, correct? That is
Two of-
Hickey and the defendant.
They parted ways when
mean, they were no
whenever he was
longer-
transferred out of Massachusetts to federal custody in Maine, they certainly parted ways.
But I thought he was moved before that, out of the cell. I mean, they weren't really talking anymore.
After this first meeting, he was a cellmate. They were cellmates.
Right.
At this first meeting in March of 2007,
There's another meeting in October.
well, after that first meeting, he goes back to the same cell. And they're going back to the same cell. And then in October of 2007, they're still in the same cell. He's transferred to Maine in June of 2008. So his bail is reduced in Suffolk, his sentence is reduced in Barnstable, and he immediately goes to Maine. He's out of Massachusetts, comes back, testifies in the Foxworth trial, and immediately thereafter gets a sweet deal in federal court, and then 1 week after that gets sentenced in his bank robbery charge in Suffolk. So you can see that everything is happening very quickly for Thomas Hickey right after this Foxworth trial. And it's all because certainly the government is pleased with his testimony.
Right,
And they-
but the question, I mean, even if he became an agent at some point in time, the issue is, was he an agent at the time he obtained this information?
Well, that's another very important point, because, and certainly I agree that there's information in the letter, and there's no agency at that point. There's been no meeting at that point. And then there's information provided to the detective at the first meeting, and then there's more information provided at the second meeting. And I
Well, the
believe
second meeting was with the ADA?
the ADA and another detective.
Okay, so there was motion to suppress, of course. Was it before Judge Kern?
Yes.
Okay. I understand your idea that there can be a wink, wink, but were there any finding by the judge that the state police officer said something, but that the reasonable understanding of it was go in there and elicit information from this guy? And although I'm telling you not to question him, what I really mean is please question him?
Judge didn't make any
She never
findings.
made any findings. There were no formal oral or written findings after that motion to suppress. She simply allowed the statement of Thomas Hickey to be introduced. So we don't have the benefit.
So it was simply denied. It was
It
denied
was
without.
denied. I believe that's correct, without any kind of findings as to what was said. So we have to rely on what is on the record. But what I wanted.
Is there anything in the record that would support your wink, wink theory? Is there anything that somebody could take that and that we, as an appellate court, could look at that record and say a reasonable person could understand from that the state police officer, although he said, don't be an agent, really meant, please be an agent, but I need to tell you this because that's what the SJC says I need to say?
That really is the problem here, because he's,
Who
on the record, he
testified?
is saying, you are not our agent, you are not to ask any questions on our behalf. This really, I mean, I would suggest this is really like a circumvention of the case law.
But
They
you
know
s-
exactly
you
what they
say
need to
that, but what are they supposed to do? I mean, unless you say as soon as the person speaks to law enforcement, automatically the person becomes an agent. But I don't know that you're saying that. You're saying that there's something that happened at that meeting that meant that there was a circumvention and that the person essentially was being asked to be an agent. But I don't know what more could be done than what was done here.
Well,
You want them to remove, as soon as the meeting is done, you want them to move him out of the cell?
Well, they certainly exploited a situation of two guys who were in the same cell. The officer knows that he's going right back to the same cell, and I agree he's not engineering that circumstance, but he's taking advantage of it. He's exploiting it.
I assume the Commonwealth initiated the October meeting, is that correct?
That is correct.
And at the evidentiary hearing on the suppression motion, was there testimony about what the detective learned in March and what he learned in October?
Well, that's another problem, that the testimony at the motion to suppress doesn't get specific about specifically what was asked, what was said by Thomas Hickey. But I can point the court to some exhibits that were in that are attached to the motion to suppress, police reports There was a report after the first meeting in March, 2 pages, 7 paragraphs. There's another report in, after the October meeting, 6 pages, 25 paragraphs, and the detective acknowledges that Mr. Hickey has added and clarified information that he provided before, and he certainly added information. And just for example, an important detail, there was some allegation of a discussion that these 2 men were going to take care of a Commonwealth witness, kill a Commonwealth witness, and that would be the immunized witness, Nancy Campbell. And that was testified to by Mr. Hickey, and he never said that earlier. He certainly never said it in his letter, or I believe in the first meeting, and it comes up later, and he acknowledged that he never revealed that information. And, Your Honor, when the court looks at those reports, you'll see that it's fuller, it's more detailed, there's new information. So I would suggest that what is happening here is there's some information that's provided, it's general, it becomes more specific after an agency relationship has been created. And it's continuing, by the way, in Maine. There's another meeting with Mr. Hickey in federal prison in Maine. And what's happening here is it's all coming together. It's all coalescing into a case. And the details are important. The details they can't just have a general confession. Guy walks up and shoots somebody. They need the details, and they need those details to corroborate what other witnesses are testifying to. And that's why Thomas Hickey's detailed testimony is so important. And it's all coming together after this agency relationship. It's all coalescing into a case for the Commonwealth. And it's at a time when, and I suggest, and I see the court's problem with the wording, but really that is what's happening here. He's circumventing the rule. I mean, we know what's going on here. These parties know exactly what is going on here. Mr. Hickey is to get information, a confession, out of Scott Foxworth. And it's very important, and he admits himself what his motivation is. He doesn't want to spend his life in prison. That's what he says. So this is very important, and Mr. Hickey knows exactly what he has to do. And as far as the issue regarding whether he asked questions or not, you'll see in his testimony at the motion to suppress, at first he says, "Oh no, I never asked any questions. I just sat there and listened." But then he admits on cross-examination, "Okay, I asked questions. I initiated conversations. We had discussions. We discussed it."
And does that matter if the questioning is not at the direction of the DA or the state police?
Well, we know that there's no getting around the fact that the state police have specifically instructed him not to. And I would suggest that Thomas Hickey, he knows that it cannot be, there cannot be an appearance that he's asking questions, because he knows he's not supposed to, but he knows what he needs. I mean, are we to really believe that he didn't ask questions, that these 2 men who are ex-cons sitting in a cell didn't
Let's
ask?
assume he did ask question. What difference does it make if it's not being done at the direction of the government?
Well, the rule is that there needs to be a deliberate elicitation. So he's going in there, I would suggest, as an agent, it's implicit, and he's deliberately asking questions. He knows what he needs to do. He knows he's been told not to ask questions. He knows what information he needs. Unless there are further questions on that point, the remaining issues I would submit on the briefs.
Okay, thank you.
Thank you very much, Your Honors.
Good morning, Your Honors. Assistant District Attorney Bethany Stevens from Middlesex on behalf of the Commonwealth. Your Honors, the judge was correct here to allow Thomas Hickey to testify to the incriminating statements that the defendant made to him. It is clear, as my brother concedes, that there can be no agency relationship before the March meeting when Sergeant Donahue went to go meet with Hickey upon Hickey's request. having been told by Hickey that he had information that he wanted to share. You can look at the letter that Hickey sent to the prosecutor in November of 2006. So this is at a time where he's been with the defendant since April of 2006. They've been in the same institution, on the same tier at times, and then they were on separate tiers, Hickey testified to, but they still had daily contact. By the time of the March meeting, Hickey had moved into the cell with Foxworth. So when Sergeant Donahue went to go meet with him that was on March 15th in 2007, Hickey shared with him the information that he had already learned. Importantly, and I put in the Commonwealth's SRA, Hickey's letter was written on legal paper, so it didn't reproduce as well in the defendant's record appendix, but Hickey's letter is on SRA 1 in the Commonwealth's brief, and it sets out the information that he's already obtained. A confession from Foxworth that he was involved in the murder, the details of the murder, the arrangement of the money and distribution of the money between him and O'Neill, who were surveilling the victim, the information about how they got the guns and disposal of the guns, and the fact that there was this map out there that led to the crime scene and that the defendant was so worried about. So that was information that was had in November, and this was again in March in the officer's police report, detailed again that same information with an additional fact about how Foxworth was worried about a surveillance video that had been turned over in discovery of a gas station that was near the crime scene, and he was concerned about whether he had actually gone to the gas station that day, whether he would be caught on video. So at the time that Hickey met with Sergeant Donahue in March, Hickey had all of the information that he wanted to bargain with. He had a confession about the murder and was telling the police, I am willing to tell you this information, and I am looking for something in exchange. Sergeant Donahue demonstrated his acute awareness of his affirmative obligation not to circumvent or dilute the Sixth Amendment right to counsel, and expressly told Hickey in front of Hickey's lawyer, you are not to ask any further questions, we're not asking you to do anything on our behalf. I am here simply to gather this information so that I can take it back to the prosecutor who was unable to attend this meeting because she had a conflicting trial. And I will take this information back and share your request. There was no plans from that meeting for a further meeting. There was no suggestion that more information was needed in order to secure some kind of benefit for Hickey. And after that meeting, Hickey simply returned back to the same situation that he had been in since April. The motion judge gave the defendant substantial leeway to explore the possibility of an agency relationship by having the evidentiary hearing. Trial counsel recognized that there was no evidence of any kind of promise that would have established an agency relationship and argued to the judge that he wanted to broaden the law and try and push this idea that there's some kind of implicit agreement just by the fact that they meet and now the Commonwealth knows that somebody wants to share information. And so allowed him to examine Hickey, Sergeant Donahue, Sergeant Baker to get a full flavor of exactly what happened. And just as it was provided in the police reports, there was no instruction, no direction, no orchestration by the Commonwealth in any of Hickey's actions.
Was there any information or any evidence that came out as a result of the hearing to the effect that the police officers had supplied any information to the defendant or to Hickey about the defendant's case?
There's absolutely no basis to find that. And
He questioned on that area?
yes, I mean, the defense counsel asked Hickey in cross-examination, were you asked questions or how did the interview go down? And he basically said, I just told them what I knew. I just, explained the information that I have. There's no basis to find that there was any information shared from the Commonwealth about the case or, evidence that they were looking for. And there certainly was the opportunity for the defense counsel to explore that. And I would just say that where Sergeant Donahue was clear about what the limitations were, there can be no implied suggestion that that was being done. And with respect to giving the instruction to Hickey not to ask any further information, I would suggest that it would not make any sense that Hickey wouldn't follow those instructions. Hickey knows that in order to get any benefit out of this, he can't be precluded from testifying. So he's not going to go against the Commonwealth's instructions to him that can jeopardize the ability for him to be able to fulfill his end of what he was hoping is going to be a good bargain for him.
But it turns out he did. He did ask questions.
Well, what ended up happening is that he went back to the jail cell and just continued in the same circumstances that he was before. And like other cases have recognized, I think it was actually an out-of-jurisdiction case, but that it doesn't, there's no requirement on this person a private citizen who's come forward on their own, to then, when the person starts talking to them about information after meeting with the police, that they have to become suspicious and act differently than they had before. As he testified at the motion hearing, he was his cellmate. It would be hard to be sitting there in a conversation and not carry his half of the conversation. But he was clear when specifically asked, and this was at page 111 of the motion to suppress, that he was not engaging in those conversations in an effort to gather any more information, and that he had some expectation that he needed to do more in order to secure a greater benefit from the Commonwealth. And clearly he didn't. The defendant had already confessed to him his role in the murder. And a very important fact that Hickey gave to the Commonwealth was this map that's disclosed in the letter. So that's before we have any kind of meeting, which ends up leading to, in 2008, when the Commonwealth spoke with the landlord found the map at the house, and then that was entered into evidence. So there's no suggestion that, the Commonwealth is saying, oh, we've got this one piece that we're looking for. Can you do something for us here?
Now, is it correct that the judge made no findings of fact with regard to this motion to suppress?
That's correct, Your Honor. And I think that's because it seems on the first day of impanelment in Volume 1 of the trial, she refers back to about how, I don't know if I was already detailed or not, but Hickey will be allowed to testify. So I don't know if she assumed that at the motion to suppress hearing, they came back later and did motions in limine, that she made some findings. But it's the Commonwealth's position that the defendant hadn't even raised an issue such that a hearing was really warranted, and that the defendant was given an opportunity to establish an agency relationship, and there's no way to read this record that an agency relationship was established. You would have to overrule Tevlin, Rancourt, and Harmon to say that merely meeting with an officer and telling them that you have information to share creates an agency relationship. The earliest time that you could find an agency relationship, I would suggest, is in October, when the prosecutor then goes and meets with Hickey with Sergeant Baker. At that time, the prosecutor meets with Hickey and tells him that we'll report to the DA's office. We'll see what we can do. We'll see if we can get authority to do something on your behalf. And that was in October of 2007. In November of 2007, he pleads out the Barnstable cases with no consideration. He gets a 2.5 to 2.5 in a day. He is then, in January of 2008, removed to MCI Concord to go serve out those Barnstable sentences. It's not until June of 2008 that the motion to revise and revoke for the Barnstable comes into play, that the bail gets reduced down to Suffolk, and then he goes to the feds, and then in August enters into the agreement recognizing his cooperation.
But
So,
Mr. Seeger says, sorry, I'm not going to
bless you.
sneeze. That, as of October, that there was a meeting in Maine in June, I think.
In September of 2008, in preparation for
September.
trial.
So, but even the one in October, if the prosecutor says, we'll see what we can do, and Hickey is elaborating on the story, I don't mean this, I didn't mean that in
I
a
understand what you're
pejorative sense, but
Yes.
does that taint what happens, whatever the information that might be supplied that you can see from the police report or otherwise after, October going
I understand
forward?
your question, Your Honor. And so if the court was to find that there was an agency relationship that was triggered in October, it's the Commonwealth's position that there's still not a basis to find that Hickey deliberately elicited information. So being an agent is not enough. You need to be an agent and deliberately elicit. But in any event, we do have from the police reports, and that's at the record appendix 29 is the March 17th report, and record appendix 32 is the October 2007 report. And in that report, starting at paragraph 17, is where it relates what happened at the September 8th meeting. And you can see that nothing in there is any extra information that wasn't already provided at the other two, meaning the letter and the March meeting, and the October meeting. There's nothing extra in there. There are more details in there, but nothing that was elicited at trial. So, even if the court was to, give leeway, I would suggest to the defendant to find an agency relationship was established at the October meeting. There's really nothing that came of that. And by January, he's now moved out of there. And the other thing I'd like to point out is that At the October meeting, it looks like he's no longer in the same cell as Foxworth. This is from the trial testimony where he testified about how Foxworth was the one that initiated him getting into the cell. There's Exhibit 97, which is a jail call on March 14th, the day before Sergeant Donahue meets with Hickey, with Foxworth saying, I'm so happy that Hickey's in the cell now. We had such trouble talking before, and now we can talk at night, and it's a big bonus to have him in the cell. So he was already in the cell at the time of the March meeting, and Hickey testified that he was in the cell for about 6 months, is what he said at the motion to suppress. He accepted defense counsel's question at the trial that it was 6 to 8 months, but that still puts him out of the cell by October. And he had testified at the trial that Foxworth had then been able to secure a single cell, and that's why they moved out, if there was any breakdown in relationship. So it's not even after the October meeting that he's being returned to the same cell. There's no indication that there's any further information, anything that's that makes a difference to the Commonwealth's case that was elicited during that, post that time. And then in January, he's now out of the institution, and as he had testified to, had no more contact with Foxworth since that time.
So going back to my earlier question in terms of the consequences of there being no findings of fact, we would need to say that no reasonable fact finder on this record could find?
I think that the court has said in Reynolds that it's a de novo review on the facts provided so that this court can determine on its own that there is no agency relationship, where it's a legal conclusion from the facts, and there's no dispute of the facts.
So you would say we become a de novo fact finder because we don't have earlier findings of fact?
I read Reynolds to say that even if you had findings of fact, that there still would be a de novo review in terms of that.
It's a de novo review as to whether there was an agency relationship. But,
Correct.
But in terms of credibility of what the various witnesses who testified before Judge Kern goes, that's different.
I would say that there's an implicit crediting of their testimony in the fact that she denied the motion. She found that there was no promise made, such that, I think by denying the motion suggests that she found no promise made, no agency relationship, and no deliberate elicitation by Hickey. I'll rest on my brief with respect to the remaining issues, and I'll just end by saying that I would ask this court not to exercise its 33E powers to reduce the verdict. Here, the defendant hunted down an innocent human being motivated by a paltry sum of money in comparison to the worth of a life, and not only caused...
That wouldn't have been better if it was
Say,
a whole lot of money,
If he was
would
paid
it?
more, you would...
Well, no, exactly. I'm sorry. But it was only motivated by a financial incentive for his own selfish interests, and he brazenly executed this person in a business parking garage on a weekday morning. And so not only did he cause the harm of taking a life and the impact that that has on the family and friends who love the victim, but also on the coworkers who discovered this gruesome scene in the parking garage and the employees who rushed to help, being confronted with such a horrific event. And I would suggest that the harm that was done here and the defendant's culpability established by the overwhelming evidence is entirely consistent with the first-degree murder conviction.
Has Mr. Brescia been retried?
Not yet, Your Honor.
Thank you.
Thank you.